Be ready for legal dictation. Start. We have heard the learned senior counsel appearing for the appellant and the learned counsel appearing for the respondent state. The facts expatiated earlier would reveal that the appellant was convicted concurrently for the aforesaid offences, and there is concurrency even with respect to the sentences imposed by the court. In such circumstances, there is, in fact, very little scope for interference in an appeal by special leave. In such cases, overlooking of a vital piece of evidence which would tilt the balance in favor of the convict appellant, or that the finding is based and built on inadmissible evidence which would impair the prosecution case, are some such situations where this court may interfere with. When the contentions raised are pitted against the evidence on record, they would reveal no such circumstances. Still, we will proceed to consider the contentions raised to find out any other tenable grounds raised by the appellant which may persuade us to entertain this appeal against the concurrent conviction. Learned counsel for the appellant contended that the plea of alibi was not properly appreciated and considered, especially with reference to the oral testimony of DW1. Despite the non-rupture of the hyoid bone, the courts wrongly concluded that the nature of the death was homicide. It is also contended that no circumstances which irresistibly pointing to the guilt of the appellant convict were established by the prosecution, though the conviction was based on circumstantial evidence. Per contra, the learned counsel appearing for the respondent state would submit that the circumstances that led to the finding of guilt against the appellant were discussed in detail by the trial court, and the High Court as the appellate court reappreciated and concurred with them, besides adding additional reasons for confirming the conviction as also the sentence. In short, it is submitted that since the cumulative effect of such circumstances relied on by the courts do not brook any hypothesis other than the one irresistibly leading to the guilt of the appellant convict, no interference with the concurrent conviction as also sentence is invited in this case. In view of the rival contentions, we have bestowed careful consideration of the said contentions with reference to the materials on record. As noted earlier, the incident which led to the death of Srimati Suman, the wife of the appellant convict, had occurred admittedly in her matrimonial home. The case of the apparent convict is that a careful scanning of the evidence on record would reveal that the prosecution had failed to establish that it is a case of homicide, and in fact it is a case of suicide. Adding to the above contentions, the learned counsel for the appellant would submit that the appellant was implicated in this case and was convicted without any satisfactory evidence, much less any clinching evidence, and also disregarding the fact that it was he who attempted to save her life, and in that regard, after cutting the noose of the ligature, he took her to the hospital. While considering the contention, we shall not lose sight of the fact that more often criminals would try to dub a murder as suicidal or accidental death. The identification of the nature of the death is therefore always an important medico legal problem. In that regard, the courts concerned have to study the total evidence to discern whether death is a case of homicide or suicide or accident. The concurrent finding in the case on hand with reference to the evidence on record is that it is a case of homicide. Presumption is only a rule in that realm of burden of proof, and the trial court and the high court concurrently weighed the circumstances and gave sturdy reasons to conclude that death of someone is homicidal in nature and not suicidal. In such circumstances, we are not persuaded to entertain the concurrently repelled contention of the appellant that the death of Suman was not homicidal. Now, the question is about the sustainability of the concurrent finding of the culpability of the appellant. Of course, various contentions have been raised by the appellant to assail the finding of guilt against him concurrently referred to in the judgments of the trial court and the high court. There can be no doubt that while dealing with such a question of creation of fake scene by the appellant, absence of explanation by the accused, despite being bound by virtue of Section 106 of the Evidence Act, is also to be taken into consideration.